Thank you, Professor Fahmy, for generously welcoming us. I'm very glad to see so many of you have joined us virtually. As Professor Fahmy already said, we were very much hoping to have been able to do this in person, but alas, circumstances have not been in our favor. Nevertheless, I believe that the conversations that we have committed ourselves to this afternoon is an important one, and one that should continue despite the circumstances. I would like to reiterate my thanks to the Center for Research in the Arts, Social Sciences and Humanities, CRASSH, at the University of Cambridge. And thank you also to the Al-Walid bin Talal Center for sponsoring this event and making it possible. Thanks to Nikki and to Neil and my other colleagues, including Luda, for all of the work that has gone on behind the scenes in welcoming you all to especially speaking to the audience members. Questions, of course, are welcome and can be asked through the chat function, which you will see in the chat box. And for most of the sessions, I will be moderating the questions. I will try my best to synthesize and pose the questions to the speakers that the question is addressed to. Questions can also be asked on the YouTube live stream. So this event is being streamed live on the CRASSH Live YouTube channel, and any questions posted there will be relayed to us by Nikki, our event coordinator. Questions can also be asked on Twitter. So if you tweet either using the Twitter handle at CRASSH Live or hashtag fostering ethics, keep track of the sort of questions that are sort of coming in. Those of you who are following virtually, whether in this meeting room, so to speak, on Zoom or otherwise. Okay. I think if you're online, and then we can kind of take turns speaking. So I was hesitant to actually do my part first, since there are others I'm more eager to hear. But I've prepared something of a presentation just to sort of as a framework for the event. So let me just comment briefly on what today's conference is about, and what's at stake and what we're hoping to get out of it. We are, of course, dealing with a big topic, and I would say bigger than it may seem, and we can't possibly cover every aspect of it. But our speakers today will help us identify and address some of the major aspects and the pressing issues under the umbrella of the topic of Islam, adoption, and foster care. We are fortunate to have a program representing a wide range of expertise and experience, both professional, academic, as well as personal. We are honored especially to be joined today by several guest speakers who are directly involved in the care community, especially here in the UK. And we will be leading up today's event to a roundtable that will sort of conclude and synthesize the course of discussions today. So we'll be joined by Sonia Hamdani, Sabir Ahmed, and Mohammed Bashir. And they bring perspectives from their own experience growing up in foster care or caring for foster children. So we have a lot to learn from them, in addition to the sort of the texts that we're dealing with that academics like myself are more comfortable dealing with. And so I would say that the highlight of today's conference will be the sort of the roundtable. And I very much encourage audience member. I know we have a very very diverse sort of representation among the audience members, and I encourage your questions, comments, and concerns throughout the event. Okay, now some of you will perhaps find the title of our conference itself a bit confusing. Are we dealing with foster care or with adoption? I think the short answer is both, but moreover, it seems that there is often a confusion between the two terms, adoption and fostering, in the Muslim community. And that's part of the problem itself. In fact, the challenge of terminology that underlies the topic as a whole, and not only in the Islamic context, I would say. So I will now load a brief, hopefully brief presentation before I turn over to and introduce the other speakers. Share screen. Slideshow. Okay, so as Professor Fahmy mentioned, I am by training a historian, and that tends to shape the way I think. So I thought that I would, to help frame the first session in particular, which we're calling Care of Children in Islamic Law and Society. And so the major themes that I see, and as well as the sort of the state of current research on the topic. This will be familiar to most of the specialists who have joined us today, so I beg your pardon for repeating things that you may already know, but I think hopefully this sort of quick survey overview will be helpful to you and to others. So I was recently taking a look at this book, which is by Peter Kahn, came out in 2013, which is a sort of a quite brief survey history of the topic of adoption itself. And something that struck me in it is this claim that, or this observation, as he sort of follows the history of adoption throughout the world. He remarks that today, quote, I quote, "Today, outside the Islamic nations, almost every country in the world has accepted adoption as a proper and legal practice and has enacted laws that govern it." So note the exception that is being made of Muslim jurisdictions or Muslim countries. This is interesting, but I should highlight the context in which he's making this statement, which is that he's actually pointing out that adoption has a very varied history and was, for the most part, not a legal institution in many contexts. Even though it has a very long and old and diverse history, it's also a complicated history, and he's pointing out the fact that what we now understand as adoption legally is a modern development, and I'll be commenting briefly on that. And that's I think that's important to recognize, and that's why I am calling my my presentation "Historicizing the Problem." To me, this also means historicizing the problem beyond the framework of Islamic history and Islamic studies. So even though I myself am by training a historian of Muslim societies and Islamic studies, so to speak, I always find it helpful, and I would insist on often, that we actually contextualize what we're talking about so as not to reinforce a kind of Islamic exceptionalism, right? So when we make statements like Islam does not recognize or Islam prohibits adoption, I'll get to that in a bit, that statement in itself may require further contextualization because on its own, it seems to suggest that Islam is the exception, when in fact the history and the context may be a lot more complicated. As Peter Kahn reminds us, right? So he points out, and this is again something that all of my colleagues who are joining here today will be familiar with, the fact that adoption, the term, is incredibly elusive. It's hard to know what it means, right? So Peter Kahn says that, quote, "Historically, the meaning of adoption, both literally, right, as well as symbolically, has varied widely over time and place. Right? Practices called adoption have ranged from the informal and often temporary care of a child or adult to the legal and permanent inclusion of a child into a new family, with several stops in between. As I said, he highlights the fact that what we now recognize as the legal institution, certainly in most Western countries, but beyond, is a modern development. And I'll just briefly note that there's something to be said about the context of that modern development itself. So I was very struck to note, given the context that we are in right now, we're all living in the midst of a pandemic. Peter Kahn notes that the early legislations, early in the sense that the first sort of recognitions of adoption, the legalization of adoption, in the UK, in France, and in other countries, it happened in the wake of the world wars, understandably so, but also in the wake of the Spanish flu, so-called Spanish flu of 1918, 1919, exactly about 100 years ago. And that context is worth remembering, and I think most of you will have seen that a lot of historians have been trying to call attention to the precedents for the world that we're living in right now by reminding us of the experience, the global experience of the Spanish flu, which instigated many of the same kind of anxieties, the same realities, the same curtailment of public life that we are also seeing right now. But of course, the impact of that, first and foremost, was in the lives of people, including the deaths of many, including, as I happen to note, there was an article in the Guardian actually over 10 years ago, by a British author, Raina James, who wrote about her surprising discovery of the story of her own mother, who was orphaned in the wake of the Spanish influenza pandemic, as her grandparents died. This is to say that this is a timely conversation, I think. It's a timely conversation in that it invites us to also consider the context that gave us the concepts that we now know of. So I'm just noting here the fact that the legalization of adoption in this context exactly about 100 years ago. So in 1920, the National Council of Women, right, they had a deputation to the Home Office debating. They had to argue. They had to make a case for legalizing adoption. This is a rich and complex story that we don't have time for here, nor is it our purpose. But I'm just sort of flagging that as worth keeping in mind. Now, the other reason why this conversation is timely is that it has become something of a recurring concern in recent Muslim debates. So here's a sample of just some of the kind of policy documents and reports and guidance reports that have been issued by various organizations, most significantly in the UK, the Penny Appeal Islamic Guidance that was issued a few years ago. And actually we have today joining with us several of the key individuals who were involved in making that possible. So my thanks to Tejjiba, who we will hear from, as well as Dr. Soraya, who will be delivering our keynote today. I should note, of course, that while these reports have come out just in the last few years, the history of scholarship in Islamic studies in Middle East is longer. So I would consider most significant a monograph by Moroccan anthropologist Jamila Barghash, who I had actually invited her, but she's unfortunately not able to join us. She's kind of moved on to a career in in NGOs in Morocco working on other social issues. But this was a very significant book for the scholarship on Islam and the care of abandoned children, including the care of orphans. And what she highlights is that Islamic law is only part of the story. Right? It exists in a social context. It has undergone transformations, transformations between the medieval period and the modern period. And very much, when she wrote the book, it was based on ethnographic research in Morocco in the 1990s. It was a lively conversation in Morocco because a lot of the family laws were undergoing transformation. And here I should note that our next speaker, Dr. Nadjma Yassari, is leading precisely a research inquiry into this kind of context. Well, how did Muslim laws, or how are Muslim laws received in the context of modern Muslim jurisdictions? So we'll have a chance to hear from her about that. It's also interesting to note, as I mentioned, that this is an ongoing conversation. And in the US, a very prominent sort of a rising star in the community, Sheikh Omar Suleiman, has written a document. This is part of the Yaqeen Institute website, where he's written addressing basically the sort of the challenges that we're talking about here. And so he notes, and here I'll move on to some of the technical issues briefly. So he writes, we need to understand issues of semantics, culture, and context. We tend to falsely equate tabanni, which for those of you who may not know the Arabic, this means literally to make one a son, tabanni, to make your ibn, with adoption. And then we say that adoption is haram, meaning prohibited. Suleiman is arguing, but that is ridiculous because, and here he's arguing that it counters everything that he outlines as the Islamic ethics of caring for orphans. Okay, so in the interest of time, I'm going to very quickly breeze through some of the other sort of contextual elements before I turn to the next speaker. In the context of Muslim discourse, obviously the life of the Prophet, the founding sources play a big role. They are the source for, firstly, of course, the source of the laws, but also the original context in which the rules made sense. But this is complicated and it's difficult. The Quran itself appears to address adoption and specifically prohibits it. This is the crux in a way, insofar as we consider the scriptural issue. Of course, there's questions of interpretation, and we may not have the scope to deal with all of that. But one of the issues is the terminology. I mean, the Quran in this verse, in Surah Al-Ahzab, is not using the word tabanni. It's talking about adiyaukum, another term that seems to, there's a sort of philological debate on what exactly it means, but the issue seems to be one of genealogy and claiming that someone is your son when they're not. The verse after that, again is held to be the source of the Islamic legal prohibition. It has an injunction to call them, right? Call them after their fathers, and not, in other words, after their birth fathers. But then note that the Quran itself says, well, if you don't know who their fathers are, then they are your brethren in faith and your kinsmen, mawalikum. For historians of medieval Islam, the term mawali is huge and significant. They were all over the social world of Muslim societies. And in fact, the story is, from the context of the Prophet's life, the story is of Zayd ibn Haritha, who was the Prophet's own adopted son until, it is said, until adoption was abolished. the interesting thing is that Zayd ibn Haritha was known as the Prophet's beloved. That became sort of his epithet, Hib Rasulullah. And I will just note that there's a lot of interesting developments happening right now in early Islamic history, including material evidence for the early community. These are hard to date. What we have here is an inscription on rock. There are thousands of these. This inscription is from Medina. It's not possible to date it. The script suggests perhaps the 2nd century Hijri at the earliest. But the text is legible. It says, it's written by someone named Zayd ibn Ayman, who identifies himself as Ahad Bani Hib Rasulullah, meaning one of the descendants of the Banu Hib. And the Banu Hib was the term that was used by the descendants of Zayd ibn Haritha, who himself was the Hib, right? The beloved of the Prophet. So there's something to be said about the memory of the early figures. We don't have much detail on, obviously, on a lot of the sort of the real context, but it's useful to think about, right, and reflect on what we don't know about the social context beyond the text, beyond the law. Okay, the other question is, what happens to tabanni? And this will, I think, come up in several of our conversations today. Tabanni meaning the term that is the institution that is said to have been abolished by Islam. It's interesting to me that we only have a handful of cases known of adoption, most likely pre-Islamic or early, very, very early Islamic. But it's interesting that, for instance, Aisha radiallahu anha, the wife of one of the wives of the Prophet herself, had an adopted son, a fairly well-known hadith transmitter of the early period, and biographies of him always note that he was or he had been adopted. He had adopted. She had adopted him, right, as her son. Interestingly, he himself apparently named his daughter after her, in other words, after her adopted mother. So this is to point out that much as in our own world today, in Muslim communities throughout the world, historically, Muslim societies had a lot of practices that either resembled adoption or sometimes literally was so. So one trace that has been identified by a specialist in medieval Islam is a case from much later in the 15th century of an Egyptian scholar who had immigrated to Gujarat in India. And in this case, it appears to have been an issue of inheritance. So he did not have a male heir. Supposedly, he adopted a son according to Indian custom, and that's what is told about him. And then, of course, there's the legal issues. I'm going to skip over this because we have Dr. Yassari talking about some of the sort of varieties of institutions in Islamic law that relate to adoption-like practices. And then, of course, there's other domains, and this is partly sort of my own interest, is like, what is there beyond the world of Islamic legal texts? Adoption or adoptive-like practices, especially the institution of milk kinship, played a huge role in medieval Muslim society and more recently. That is to say, you can think of this as the sort of the milk and blood, right? The two sort of fluids that mediated relationships in Muslim history. Now, turning to the more recent context, I think today we're most familiar in the Muslim world, most familiar with the care of orphaned or abandoned children in the sort of institutional context of either state-sponsored or NGO or charity sponsored orphanages, and that too has a history. It has a history in the sense that they're very. Historians have tried, but it's been hard to identify exactly what we understand as orphanages in the medieval world. So one historian who has looked at sort of the emergence of orphanages in the late Ottoman context, he sort of basically claims that there were no orphanages in earlier history because the role was turned over to families, right? And this is something that I think will be familiar to all of us. The kind of informal practices that guide. Okay, so I'm just flagging the sort of the scholarship, as I said. So particularly notable the work of Nazan Maksoudian, who has looked at the how the late Ottoman Empire. So this is, I'm dealing specifically with the Middle East in the late 1800s, early 1900s. What are the sort of radical transformations that happen with the kind of the first sort of state-sponsored orphanages in the Muslim Middle East at the end of the 19th century. Beth Barron has written a very interesting book on the role of Western Christian missionaries setting up, kind of filling the gap, so to speak, right, where the state capacity may not have reached. They were able to play a role. I mean, Beth Barron's book is far more interesting than my summary can do justice, because she looks at how actually Muslim welfare organizations, at least in the case of Egypt, started out as a reaction to the sort of anxieties about Christian missionaries fostering Muslim children. Of course, anxieties about proselytization, conversion, and things like that. Another issue, other than the kind of rise of orphanages, this is something that comes up a lot. I think most of you will have heard of. And that's, again, the crux of the issue of tabanni, the standardization of names. What I mean by that is the fact that one of the anxieties in Islamic law of adoption is the sort of concern that calling somebody after someone else, in other words, your genealogy, a nasab, a lineage. But here, I think I will just highlight the work of Meltem Turkos and hopefully others as well. But Meltem Turkos has done a really interesting study on the surname law change, the surname change law in the context of Turkey, where the archive is fascinating, and she points out how the law, and this is not exclusive to Turkey, we have in many countries there were similar laws. And I would say, I mean, based on my own experience in Bangladesh, it's a sort of an incomplete modernization project, the sort of the issue of standardizing names. So what it means is that it's not so clear cut that, when we say that, well, Islam does not prohibit changing your surname, Islam prohibits changing your surname. What does surname mean in our world today? Okay, to summarize my kind of framework, so as I said, this is the sort of framework to start the conversations for today. My historian's perspective is that, firstly, that it's important to think of the Islamic legal issue in context, not only of Islamic history, but beyond. And secondly, that the terminology, that the names, right, what terms we use are an issue, but also that those terms are not fixed, because as context changes, the meanings of those terms also change. So in the medieval world, where milk kinship was a big part of life and society, fostering meant one thing. It didn't seem, say, as alien in the way that it might in modern Muslim context. And secondly, the historical developments with modernization that affect pretty much all of these issues. So I will end my presentation there, and I will now turn to the formal panelists that I have assembled. So first, I will turn to Dr. Nadjma Yassari, and I will introduce each of our speakers. So assuming you're ready, Dr. Yassari? Yeah. Okay. Just do remember to unmute yourself, and I will mute myself as soon as I'm done introducing. Okay, so I'm very excited to introduce Dr. Nadjma Yassari, who is the director of the research group on changes in God's law and inner Islamic comparison of family and succession laws at the Max Planck Institute for Comparative and International Private Law in Hamburg. She also teaches at the University of Hamburg, Originally from Tehran, Dr. Yassari studied law in Vienna, Paris, and London. She holds an LLM from the University of London, SOAS, and an LLD from the University of Innsbruck, Austria. She was awarded a postdoctoral habilitation from the University of Hamburg in 2016. And her main fields of research are national and private international law of Islamic countries, in particular the Arab Middle East, Iran, Afghanistan, and Pakistan, with a special focus on family and succession laws. She's speaking today about the placement of parentless children in new homes in Muslim jurisdictions. Thank you, Dr.
Hi, thank you very much for the introduction. It's my first Zoom conference, so if I misbehave on the rules, I'm sorry. I have this desert background because I wanted to eliminate the chaos at my home at the moment. So I'm going to talk for 15 minutes. That's the time limit. So what I want to talk about is how I came to research that topic and what kind of trajectoire I had to go, which will reflect also what Arafat said about the ways in which people look at tabani adoption, or however you might want to call it. So the whole research started with a request from a court in Germany in 2011. A binational couple, a German father and an Iranian mother, had gone to Iran and had taken into their care a young boy who was then 3 or 4 months old under something that the authorities in Iran called sarparasti, and which was translated into adoption in English for the purpose of the papers. Now, the German father went to the German embassy to get the nationality for the child. And the embassy said that for that child, the nationality of the parent wouldn't transfer to the father. So they said, okay, fair enough. If you do not accept that, give us a visa so we can go to Germany and have the child adopted in Germany. Again, the embassy refused. And what's interesting is what they wrote into the letter rejecting that. They said that they could not legalize something that was prohibited in the country where they were, and I quote, the Quran would prohibit adoption, they could not issue a visa. So you can see the idea of the German civil servant upholding the rules of the Quran, which would be a task they probably didn't think of when they started the job. So anyways, what the parents did is that they went to Turkey because they didn't need a visa, and they smuggled the kid out of Turkey and brought it to Germany. And they went to the court and said, we smuggled that child. It's our child, we adopted it. And we don't want to go through the adoption procedure again. We want to have it recognized as an equivalent to adoption or as adoption under German law. And I will tell you the story, the end of the story. The child got adopted, and this family also has a new little daughter now together from Iran. So the story ends well, but the way to that result was a bit difficult, because the courts are under the impression that, first of all, Muslim law or Muslim jurisdictions is all the same. Somebody taught them that there is something called kafala. So that's the only thing that they know. That's the only word that they use. And then Muslims are, Muslim law or like Islamic law would be the same everywhere. And so we started to look at what was the way we went on. So the first thing we did is I looked into this judgment from the Iranian court, and I found out that there is a law from 1975 that would transfer parental authority, parental care from of a child of unknown filiation to completely alien people, and that these parents had to make an irrevocable will as well, so to fill in the succession rights of that child. The child would be under the supervision of the court for a trial period of 6 months, and then the final decree of, it's called sarparasti, would be given to the new parents, and without the supervision or oversight of any courts, the parents had full parental authority. So then I thought, what is adoption in German law? What would be the difference between this and what happened in German law? Now, German law affords all this to an adoptive child, and German law only knows the full adoption. So in Germany, when you're adopted, you are like a biological parent, with one little exception. Then I thought, okay, that's Germany. The Germans are very, ruly. What about other jurisdictions? How do French do adoption? And, I grew up in Austria, so my first focus was on Austria. And I found out that the Austrian had something, they don't even call it adoption, they call it kinship by choice, so Wahlverwandtschaft. And under that scheme, the child retains his relationship with its biological parents. It retains its name if it wants, and it has relationships with the new parents, but they're like two parallel systems that are built. Then I went into France and I realized that France and other countries that are influenced by the French Code Civil, have two schemes. They have the full adoption, adoption plénière, and they have the simple adoption, which is like a light version of adoption, where not all the linkages with the biological family are severed, where succession rights remain, where a whole lot of effects of biological relationships are not transferred. And then I went on and I said, okay, what are the effects of giving a child into the care of others? What kind of relationship must I check to see what is the essence of that relationship? And I realized that under the term adoption, we understand a lot of things. And not only today, but also historically, it could mean completely different things. So I traced the Islamic and pre-Islamic patterns of adoption. I'm not going to dwell on that because Arafat talked about it. But the result was it had not really something to do with the care of minors. It had different reasons and different aims, but it wasn't like bringing a parentless child into the care of a new home family. So, but if we take this as the notion that we have, at least for the last, let's say 50, 60 years, what would be the essentialia adoptionis? What would be the essence of any structure that we could think of being equivalent to that? And I wasn't thinking to tell Muslim jurisdictions who claim not to have tabani that they do. That's not my aim. My aim was it's not that important. It's more important to see what is the function of that legal structure. And so I came up with the idea that there might be three points that if we have these three effects by that legal relationship, we might think of it as an equivalent to adoption in domestic law. So I went through all the effects that adoption could have. And I realized that the first and foremost important thing is the transfer of parental authority. So without the rights and duties of parents to oversight, to education, and to upbringing, to maintenance, we can't talk about adoption. So we would have to have this complete transfer from the biologic parents, if they do exist, or from the state, if the orphan is an orphan of unknown filiation, to the new parents. That was the first point. The second point that I found in all the jurisdictions that I scanned through was that the relationship must be of a permanent nature. So a relationship that ends when the child reaches majority in particular wouldn't qualify for adoption, because adoption in his idea is a bond that is made for forever, actually. And the third thing, and that is like the modern part of it, is that this is the idea that came to me from German law. German law, in their definition of adoption, just says that an adoption is the placement of a child in a new home for its best interests. So it's just with a view to the best interest of the child that that child is given. So this would be the three criteria I was looking for: to have full parental authority and care, to have the creation of a permanent bond that doesn't sever at majority, with the canvas that there might be some reasons for which that relationship could be broken, but not time. And the third thing would be to have it in the best interest. And then I scroll through. So at that point, I realized that this is a huge project. And even though I know Farsi and I'm acquainted to Iranian law, I might need other people. So we created that project, the Max Planck Working Group on Child Law. And I think one of my co-authors is listening. Is Catherine Hoffman is online too. So hello, Catherine. So we had a lot of discussions to find out what kind of terminology are we going to use, what kind of structures are we looking for, what does it actually mean somebody is the child of someone, beside the legal framing of it. So what is all the social and economic concepts that underline the ideas of legislators when they think of structures to bring children into their home. So this was the beginning of the project, and we wrote a book. I have the book here. I don't know if it's going to be seen here. So this is the book that came out. So if you're interested, I can give you the link. So we have 11 countries, and we discuss what does it mean what is nasab, what is filiation, how is it created, why didn't Muslims use the concept of iqrar, of acknowledgement, more often to make adoptions? Because we realized they didn't, and we weren't clear about that. We tried to bring on board scholars of history and scholars of really Islamic law, because I'm a contemporary lawyer, to find out all the context that would fit in. And we actually said that, let's say the result was we have now knowledge about different jurisdictions, and some would fit into the definition that I gave. So for example, Iraq has a structure that is very similar to Iranian law. And we were also successful in having Iraqi children recognize it's called them. The Iraqi them was recognized in German courts as an adoption. I argue that the Algerian kafala qualifies as well for adoption. But then there are other structures which do not qualify for the sake of recognition. What is interesting, and this is like the last points that I want to make, not to overdo, is the ideas that legislators have when they're trying to devise such a law. And these ideas, I could trace them, because the law that I was working on in Iran was from 1975. And in 2013, there was a new law. And the background was that in 1975, there were no statutes to care for parentless children, for children who were orphaned or children whose parents were not fit enough to care for them. There was no legal rules to bring them into new families. So in 1975, they made that law. But that law was very, very strong in terms of establishing exactly what I talked about, a permanent bond with all rights bestowed on the new parents, and very few rights of the biologic parents to reclaim children that had been given in adoption just because they were unfit to care for them. So in 2013, the new law that came out differentiated between children who were of parents that were, for certain reasons, unfit to care for them, mostly because of drug abuse. They were taken from the parents, and children that were of unknown filiation, in particular in the aftermath of earthquakes and other natural catastrophes, and orphans who could be taken into a permanent care by new parents. So the new law differentiates between what we would call foster care for children who could potentially go back to their parents, and children who can stay permanently with the new parents. So, and all the discussions that were surrounding that law were extremely interesting to see how the society perceives of that. So there is still a bias on taking on children that are not your biological children. There is this idea of children without parents might have some, which we don't know, problems that cannot be resolved. There is also the idea on the other side that in most orphanages in Iran, when people come to choose a child, they would choose the boy. They would choose a boy. So the new law says that unwedded women, so women who haven't married or aren't married, so they could be widows, divorced, or not ever having been married, they may also take into their care a girl. So to make sure that girls can also be prioritized when women who have no husband would want to have a child. With all the problems that come with that when that woman wants to get married afterwards, because there is a problem with that too. So the society was open to having those schemes applied in practice. There is a bias towards children who have no parents for whatever reason. There is this idea of we don't know who they are. At the moment, it is applied. At the moment, the law in Iran is also, the scheme of sarparasti is recognized in most Europe, in Germany and some European courts, but there is still a lack of knowledge in the community in Europe. What is the difference between tabani and kafala? What is the difference between fostering someone and being responsible as a parent? What is the relationship between adoption and succession? Is succession something that we really need for adoption, or is it beyond that? What is the relationship after majority that is still in place? What kind of legal effect does an adoptive relationship have after the child has reached the age of majority? So we touched on the basic structures to get into the discussion, but I think we still have a couple of open questions to resolve in the couple years to come. So that's where we stand today, and I hope to get some input for the future. Thank you.
Thank you, Dr. Yassari. Very, very insightful. Despite how concisely you managed to summarize a massive project, and I should say that I think there was another book before the book that you showed, and so really incredibly useful resources for specialists, for scholars, for lawyers, for refugee advocacy experts and others. And I think what you pointed out is that there's much that somehow that we just didn't know about. I mean, the sort of the common assumptions that even courts were making in Europe. So that to me was really striking. I'm sure our audience members have questions. I will ask that you please keep your questions in mind. We will collect questions. I mean, you're happy to sort of send them along now, but I will turn now to our next speaker, and then we'll sort of close the panel with a Q&A. So I'm very delighted to introduce Dr. Nermeen Mufta, who's joining us from the US this morning for her. She is assistant professor of religion at Butler University in Indianapolis in Indiana in the US. She received her PhD from the University of Toronto, as well as graduate degrees from University College London and the American University in Cairo. She has published in comparative studies in South Asia, Africa, and the Middle East, International Journal of Middle East Studies, and Contemporary Islam, and elsewhere. The title of her presentation today is Muslim Americans Negotiating the Islamic Law of Adoption, Expertise, and Advocacy and Ethics. Thank you.
Thank you. So I will be relying on a script, but hopefully we'll keep it lively. The Muslim orphan lives a paradox. At once the intense focus of alms, because they're often taken as the paradigmatic figure in need, and yet often scorned because of their perceived rootlessness. Giving to orphans is among the most popular forms of obligatory and voluntary almsgiving. Yet, while care of the orphan is a much lauded form of giving, precisely what care should look like is highly contested. This is due in large part to a consensus among the Islamic legal schools that adoption, tabani, is prohibited. The prohibition of adoption in the Islamic tradition has not hampered, as we've heard, but in fact may have given rise to a number of formal and informal mechanisms of care, including the social institution of kafala. Still, while Muslims today are primed to financially support orphans and orphanages, there is heated debate about whether and how to raise a non-biological child within one's own household. So within the study of Islam, and so I'm a little bit odd, I'm trained in religious studies, but I'm an ethnographer by sort of methodological practice. So within the study of Islam, orphan care has largely been examined by scholars of Islamic law. Yet, as historian Amira Sanbul points out, historically, there is a disjuncture between jurisprudence and how Muslim societies have actually coped with abandoned and vulnerable children. While the refrain that adoption is prohibited is common among Muslims, this shibboleth is illustrative of a challenge in managing the concept historically and across cultures. As a result of the gap between law and practice, we need a fine-grained understanding of the social life of the law. This means examining not only the role of jurists, but also how Islamic law is taken up, subverted, and often ignored by Muslims. So how do Muslims negotiate the legal, biological, and affective realms of the care and abandonment of vulnerable children? Today's talk is part of a first stage in responding to this question by outlining the orphan paradox as it's structured, experienced, and debated among Muslim Americans. Specifically, I'll be talking about orphan advocates and adoptive parents as they navigate Islamic law. Islamic law is not always determinative for guardians, of course, but it's a dominant framework for many of their deliberations. Even when they dismiss a particular interpretation of the law to pursue a different ethical vision of either care or family, they are often surrounding conversations about what constitutes the Islamic, whether that's within families, whether it's those conversations with extended families or their community and so on. So today what I'll do is I'll offer 3 snapshots to tell this story. The first depicts the effort of the first Muslim adoption agency in North America to advocate for what they were calling Sharia compliant adoption. And the other 2 stories will turn to guardians. Through a woman I'm calling Aisha, and guardians I use pseudonyms, but for advocates, they're public figures, I'll use their names. So through Aisha, the first guardian, we'll see what I call Fiqh ambivalence, a viewpoint that does away with or is critical of Fiqh as a dominant dimension of the Islamic tradition. And the final snapshot turns to Asif, who I use to depict what I call Fiqh pragmatism, a perspective of a minority of Muslims who consciously refer to Fiqh as a daily resource for correct living. He charted a path between different legal schools in order to find solutions that worked for his family and also satisfied legal guidelines. So Fiqh is a space of ethical deliberation in which questions of whether something is Islamic or permissible are posed and worked out. The issues that Muslims frequently cite as stumbling blocks today among my interlocutors around kafala, let's say, / adoption, are questions of inheritance, maintaining a child's identity as distinct from their guardian family, and the preservation of modesty within mixed gender home, or what those engaged in these discussions gloss as the mahramiyya issue. So research for this paper, here we go. Research for this paper is part of a larger ongoing research project, Guardians of Faith, Orphans and the Remaking of the Muslim Family. So today's paper is based on 4 years of fieldwork in the United States and Canada, drawing on ethnography from public education events, community meetings, online support groups, national databases, in-depth interviews with adoptive parents, adoption advocates and their critics, as well as Islamic scholars trained in Islamic as well as Western academic institutions. The larger project examines 21st century meanings of guardianship, connecting prominent networks and institutions of Muslim orphan care from flows between the global North, Canada and the United States, and the global South, the two Muslim majority countries that have large rates of child relinquishment and that uniquely facilitate inter-country adoptions to North America. That's Morocco and Pakistan. And I've just started the field work about a year ago for that. I won't be talking about it in the talk, but I'd be happy to talk about the larger project in the Q&A. So the first snapshot, the meanings and predicaments of Sharia compliant adoption. New Start Kafala, the first Muslim adoption agency in North America, was a significant contributor to public education on Muslim adoption and orphan care. The agency was formally established in 2014 with some people who had actually been working sort of ad hoc facilitating inter-country adoptions, as well as a lawyer and some adoptive parents. There's an interesting history to New Start Kafala. Their license was canceled about a year ago, which is a whole separate story again that I could talk about in the Q&A. But what I want to address today with regards to New Start Kafala was their focus on trying to get a kind of formal certification from scholars within the United States where they could call what they were doing Sharia compliant adoption. So the idea of such a thing strikes many Muslims as a contradiction. For those with New Star, though, kafala is the obligatory response of any Muslim to an orphan in need. They regard the necessity to respond to the plight of vulnerable children as a test from God. This kept coming up over and over with guardians and advocates. And they saw the treatment of Muslim orphans as a serious plight on the Muslim community, who they regarded as misinterpreting the Sharia in the prohibition on adoption. On the other hand, for some of the communities they encounter in America, Morocco, and Pakistan, adoption is haram and nothing can make it otherwise. So New Start promoted Sharia compliant adoption as a way to circumvent challenges to the permissibility of adoption. Their language also sought to appeal to Muslims who were unfamiliar with the concept of kafala. Their leadership often turned to imams and fuqaha to discuss adoption with their communities and authorize this Sharia compliant adoption. And different scholars reacted to this request in different ways. So they did have partnerships with, for example, the Fiqh Council of North America and other institutions that write fatwas for a North American audience. No such certificate was issued in any sort of way that they felt would be helpful for advertising, but there has been the creation of various guidelines to guide Muslims through an adoption process. So Sara Haidar is one of the co-founders of New Start Kafala, and she explained to me the idea of Sharia compliance in this way. So in this image, you have her with who we've already been introduced to, Sheikh Omar Suleiman. And this is a clip taken from a YouTube video that was widely circulated among interested Muslim couples who were interested, prospective parents in guardianship. So I'll quote her here at length, explaining this idea of what Sharia compliance means for her. Everything we do is in the best interest of the child. That piece is essential. We educate ourselves and communities on the Islamic way of caring for orphans within one's household. We offer the education and support to act as a guardian in a way that follows the fiqh. Sharia compliance also means informing the Muslim community about the myths and misconceptions of the fiqh on guardianship. It is also crucially about providing ongoing support to the families that have adopted through New Star, including family reunions and developing sibling relationships among adopted children in different families. So Haidar's understanding combined sort of legal terms like the best interest of the child with fiqh, as well as education, community, and relationship building in terms of what makes their work Islamic. In other conversations, leadership discussed some of the predicaments that arise in navigating Islamic law in the inter-country adoption process. So Yusra Goma, a former New Star board member and founder of a separate organization, Muslim Adoption Network, discussed the challenges of following Sharia for children of unknown parentage, who make up the vast majority of abandoned children in Morocco, and who are brought to the United States through inter-country adoptions. A key part of the Sharia is that a child knows their identity, and no form of fictive kinship is at work in a guardian-ward relationship. So in this way, what is today known as open adoption is conducive to kafala. Yet, since many of the children in Morocco are of unknown parentage, this makes open adoption impossible. So Yusra underlined the impossible conditions for creating an open adoption, or one that would be uncontroversial from a Sharia perspective. Not only is this where Sharia compliance is a challenge, it is also where the question of orphans as a test to one's faith is most apparent. And so the other co-founder, Wafat Benani, she was particularly concerned about children in this category. Since it is these children who face the greatest stigma. So having come to co-create New Star following experiences with orphans in her native Morocco, she explained that many Muslims she speaks with in her work refer to abandoned children as haram children. And she was really troubled by this and asked me, what could a person mean when they say a child is haram? So through New Star, we see advocacy trying to bring Islamic law on board with their work. Faced with this common refrain, adoption is haram, they tried to work with scholars to give their work religious legitimacy. I'll turn to the second snapshot and the first of our adoptive parents. Aisha was deeply ambivalent about fiqh as she arranged her foster to adoption process in the state of Illinois. She and her husband were raised in the Midwest by immigrant parents. Hers came from India, his from Iran. She explained how she felt guided to care for vulnerable children as part of her religious commitment, and yet at times burdened by a fiqh that posed logistical complications. At times, she felt that Muslims around her misunderstood the more important imperative of caring for vulnerable children in their efforts to satisfy fiqh requirements. She highlighted common concerns raised by a number of my interlocutors. It also pushed beyond the issues of identification, inheritance, and mahramiyya as a result of the experiences she faced in her foster to adoption process with two African-American girls who, before joining her, had attended a conservative Christian church when they were young. Her experience of racial and religious difference within the household suggests a new horizon for ethical and practical quandaries facing American Muslim adoptive parents. At the same time, her efforts to placate the concerns of her parents in her family planning decisions are typical of shifting generational concerns today. So Aisha was reflective about her fostering process and her relations with other Muslims. She raised questions regarding whom Muslim Americans perceive as deserving and desirable of care. Aisha participated in public education forums and online support groups for Muslims who were basically researching foster and adoptive processes. But she was concerned that most care was directed towards particular groups, specifically refugees, specifically Syrians, and not towards American children in the American system. When we first met in summer 2016, she explained that she wanted to adopt from a young age, but felt resistance from her parents. And again, this was common among my interlocutors. Her mother, who she described as more orthodox, was anxious about the mahram issue. Her mother worried about how her daughter and her husband would maneuver stipulations of gender decorum in the household. For Aisha's mother, it would be inappropriate to have a young girl in the house with Aisha's husband. Aisha felt, as she put it, just like frankly insulted. She saw the need to give children homes as being the much more urgent moral concern. The fiqh around gender decorum felt like a constraint on her ability to live a deeper Islamic ideal. From her perspective, the need to satisfy fiqh regulations on gender within the household missed the moral imperative to care for vulnerable children. So while she did away with concerns of the mahram issue, she thought about Islam regularly. It was really an orienting framework for her life. So the kinds of conversations that we had about the Islamic issues she dealt with had to do with things like, how would she describe death to her two daughters, for example. So these were young girls who had gone through trauma, and she was concerned about not re-traumatizing them, and yet at the same time giving them what she described as an accurate Islamic perspective of what happens after death. So she would seek out religious authorities. She had a community in Chicago through Ta'leef Collective that gave her a space to ask the kinds of questions she needed to ask about how to Islamically raise her daughters. And the final snapshot. Asif recounted how he and his wife adopted a baby girl, a foundling, from an Edie Foundation orphanage in Karachi, Pakistan. And Edie is, of course, a well-known social welfare organization and famous for their orphanages. He described how they managed fiqh through a complex process of ethical and legal considerations. At the time of the adoption, he was a doctoral candidate in an Islamic studies program known for its training in classical texts. In his 20s, he and his wife, Sadaf, pursued Islamic education in Cairo. They're among a minority of American Muslims who are what Rumi Ahmed calls fiqh-minded, deeply concerned with and literate in applying Islamic law in their daily life. He and his wife, however, followed different madhabs. So Asif was Shafi'i and his wife is Hanafi. The legal schools have different specific regulations on matters related to guardianship that Asif and Sadaf managed in relation to Pakistani law, which as it pertains to guardianship is Hanafi. During the process, they found themselves faced with significant decisions on how to create a relationship with their daughter that would best follow the regulations of guardianship. As Asif put it, we're trying to make fiqh work for us. To satisfy issues of identity, they made a public announcement in the newspaper, so that matter was settled rather easily from a fiqh perspective. However, it was the mahram issue, like Aisha's, that was more sticky and caused greater troubles for them. And again, I'll quote him at length here. He said, "For me, if there's an out, I'll take it. We spoke to others who said the same thing. We heard all sorts of different perspectives. I was inspired by an African-American woman who warned me not to be too dogmatic. She hugs her son, but still covers her hair in front of him. On the other end of the spectrum, I spoke with a scholar I respected. He offered the worst advice. He suggested that I should marry my daughter and then divorce her when she is ready to marry. I still respect him, but it made me want to throw out the whole edifice." The advice to marry his adopted daughter would have created the conditions for his daughter not to cover her hair in front of him. Such a marriage sought to create a loophole, hilla, that would ease relations across genders within the home. While the advice was concerned with the law of appropriate mixing, for Asif, the solution was tone deaf to the father-daughter relationship. He established, I'm short on time, so I'll just briefly tell you about his efforts to try to create a milk bond with their daughter. So this was, again, an issue of real concern for them, and they opted to take the Hanafi perspective, which was a little bit easier than the Shafi'i one, to create this bond. So the Shafi'i one would have required enough milk from his wife to actually nurture the baby, to help create building the bones. So they opted for the easier restriction. And they also had other family members offer their daughter breast milk. So he actually became both father to and uncle to his baby, or through the daughter, through milk kinship bonds. So as he concluded a lengthy explanation of how they satisfy these legal stipulations, alhamdulillah, from a fiqh perspective, were covered. So while Asif and Sadaf's knowledge of religious law makes them rather unique among Muslim American adoptive parents, their deliberations were similar to others in many respects. Much like parents like Aisha, who were more ambivalent in their relationship to fiqh, they strategically moved between legal schools based on their sense of their family's needs and what constitutes an appropriate father-daughter relationship. Ultimately, they demonstrate a rare fidelity to the tools available to them through fiqh, as they interpreted kinship within their household and with their extended family. So just to wrap up quickly, today, Muslim Americans contemplating child welfare wrestle with how to balance the Islamic imperative to care for orphans with the widely accepted prohibition on, let's say, so-called adoption. This leads many to articulate orphans as a test of conscience for Muslims. Contentions over how to respond to orphans as a test from God both incorporate and rebuff contemporary norms of international and Euro-American adoption. This tension makes Muslim debate surrounding child welfare a crucial site for investigating the ethics of adoption. An understanding of Muslim debates and alternative mechanisms of care may provincialize Euro-American norms of adoption, commonly seen as the exclusive methods of ethical care. Alternative approaches to orphan care that emerge from the Islamic tradition echo considerable concerns over contemporary adoption made by American organizations such as Parents for Ethical Adoption Reform, among others. In other words, Muslim debates regarding the care of orphans are not indicative of a peculiar resistance to established norms of adoption and fostering, but can instead be illustrative of ongoing developments of how social workers, lawyers, and families negotiate the ethics of orphan care.
Thank you, Dr. Mufta. Okay. That was really fascinating and raises a lot of interesting questions, spanning both kind of diaspora, so to speak, diaspora Muslim communities and their relationships to Muslim countries with their own laws, and then the interesting and complicated question of what fiqh means in the lives of Muslims. And I think we'll see in the course of our next few presentations, especially in the last session where we're going to dive into the sort of conversations here in the UK, how families deal with these questions. We have one more presentation before I turn to, before I open the floor for questions. Some of you have already written, which is great. Our next speaker addresses Rositsa Atanasova, will address an issue that I think is very much the backdrop of this entire conversation and has been for the past few years, which is that particularly in the wake of the civil war in Syria, the ongoing disastrous and really painful kind of events in Syria and its ramifications, especially in the Mediterranean, across Europe and beyond. And I think the sort of the so-called refugee crisis and the migration crisis everywhere really seems to be a part of what's driving some of these kind of concerns as it involves children. So I'm really excited to have with us Rositsa Atanasova, who is joining us today from Sofia, Bulgaria. She is a legal professional who has worked for a range of NGOs in support of migrants and refugees in Bulgaria. She led a project at J.K. Rowling's Lumos Foundation, aiming to provide alternative care for migrant and refugee children in Bulgaria. Rositsa completed a Master of Theological Studies at the Harvard Divinity School, which is actually where we met many, many years ago. She focused there on Islam, as well as, and then in subsequent to that, she did a law degree here at the University of Cambridge with subsequent specialization in European law. She researches, publishes, and presents regularly on Islam and religion in Bulgaria, migration, human and child rights. She's speaking today about care and protection of Muslim children in migration. Thank you, Rositsa. You're on mute, so please unmute.
Thank you for reminding me and for the invitation. It's very great pleasure for me to be with you today and such eminent presenters. Very fascinating topic. I'll just now load my presentation. Very interesting presentation so far, and I think touching on very important issues, mostly within the domain and the legal order of Islamic law. And I will develop on some of the things that were said and hopefully add some nuances. Like you said, a lot of the discussion, particularly about fostering adoption in Islam, kafala that gets thrown around a lot, has occurred in the context of the recent so-called refugee crisis and as an alternative form of care, particularly for children, mostly of Muslim children without parental care for one reason or another. I just wanted to start with this slide just to see what other legal orders apply in this situation. So if we have a migrant or a refugee children and a child, I want to make that distinction because it might not be apparent to everyone present. So a refugee is someone who fulfills the criteria of the Refugee Convention. That means someone is individually prosecuted on the basis of ethnicity, race, belonging, political opinion, belonging to a particular social group. A migrant is someone we accept that is more or less voluntarily moving and crossing borders. So it's not really the individually targeted or prosecuted. We have now in Europe another form of protection, so-called subsidiary status, which means that even though someone is not individually prosecuted and does not fulfill the requirements of the Geneva Convention, if their life is endangered due to indiscriminate violence, as often happens in conflict, they could be granted international protection in that form of subsidiary protection. The line between refugee and migrant is not very clear cut, and there's a lot of political speculation, of course, with that, trying to discredit the claims of many people, claiming they're not true refugees, but they're migrants. And as I said, there is really a big debate whether there's really a clear distinction between the two categories. I'm showing this slide because I wanted to show that even if a child is not a refugee, so doesn't fall within the category of refugee law, human rights law and the rights of the children rights law still apply fully to that child, regardless of where they are. So as long as the state on whose territory the child is at the moment has ratified the Convention on the Rights of the Child, to which we'll get in a minute, that child holds exactly the same rights as a child that has the nationality of that state, plus all the human rights guarantees that are applicable. I wanted to start with the regime of the Convention of the Rights of the Child. It is by far the most rapidly and widely ratified human rights treaty in history, which really shows broad consensus about the standard of protection we want to give children. It was drafted in 1989, and only three countries have not ratified the convention: Somalia, Sudan, and the US, even though the US has ratified some of the protocols to the convention. But that means that even most Muslim countries have also ratified the convention. Of course, some of them with reservations, and I'll speak about that shortly. But the convention gives us 4 fundamental principles. First of all, just the general idea that the child is a rights holder, and the state has obligations towards the child to ensure that the particular standards in the convention are met for each individual child. As I said, regardless whether they're a national, whether they're a refugee or a migrant child. So there are 4 main principles that underpin the convention. It's the principle of non-discrimination, which is in Article 2. That means we cannot discriminate on any of the characteristics of the child: ethnicity, race, migration status, etc. The best interest of the child is not in Article 3 of the convention. This is a fundamental principle that needs to be taken into consideration in all actions and decisions made with regard to the child. The convention also guarantees right to life, survival, and development in Article 6. And according to the maturity of the child, the child is also entitled to express their views, again, with regard to the decisions and actions that are taken for them or on their behalf in Article 12.
I was sorry interrupting. Is everyone seeing her slides, or?
Yeah, let me know if there's an issue.
Yeah, so I think we're only seeing your PowerPoint sort of first slide, and we're not seeing.
Is it frozen?
Oh. Maybe. Yeah. Did you press slideshow? Like.
Yes, I am moving
okay.
it now on my computer.
Okay, but I
think. Do you want me to load it again?
Yeah, let's try loading it again. I think maybe it was frozen.
Do you see it now?
No, I think we're having the same issue. Okay, let me, maybe I'll try. Should I try to load it from our side?
Let me see if I can just not share the application, but my screen.
Okay, that works too. Yeah, perfect.
Okay, great.
Okay, that works too.
Okay,
yeah.
Perfect. I want to also touch on the provisions of the convention that specifically speak about the needs of children deprived of parental care. Obviously, the standard of the convention is that children need to grow up with their family. That's why Article 18 says that parents and guardians have primary responsibility for the upbringing of children. And they're supported in that function by the state. Article 10 explicitly also speaks about the importance of family reunification and the state having to proactively take actions to ensure that a child who's deprived temporarily of parental care is reunified with their parents as soon as possible. If a child is deprived of a family environment, it's an obligation that the state ensures alternative care. Here we have the convention itself doesn't make this distinction, but it's an important distinction. is it, and this is the context in Article 20 that we encounter kafala, the mentioning of kafala in the convention. So it says that that form of alternative care could be foster placement, kafala of Islamic law, adoption, or if necessary, placement in a suitable institution as a last option. Of course, in alternative care, we have short-term foster placement and a longer-term foster placement. And you will see that how that applies in the case of unaccompanied children. It's in my discussions with Arafat, we were mentioning that kafala here is almost an attempt from the drafters, and it was very much so, to include the Islamic countries who are very strongly objecting to the inclusion or the possibility of adoption in the convention. But as we will see, the two are not equal at all. This is why Article 21 was drafted as saying state parties that recognize and permit the system of adoption. This was drafted on purpose to ease the fears of Islamic countries or Muslim countries that the convention somehow imposes adoption, even though many Muslim countries still filed a reservation to Article 21, even though it has this sort of drafting. What is interesting here is that kafala almost seems like a lip service. We don't know substantively whether it really equals all of these other mechanisms, and it was really left to the individual jurisdictions to see if they recognize it as equivalent or not. Article 22 explicitly then mentions that, as I said, the same guarantees and rights apply to refugee and asylum-seeking children. So even if these children are outside of their country of nationality, as long as they're on the territory of a state who has recognized the convention, all of the convention rights apply to them. So that would be all of the countries of the European Union. In 2009, the UN guidelines on alternative care of children were published, and those elaborate a little bit more the convention standard for the provision of alternative care. Kafala is mentioned 4 times in the alternative care guidelines, and it always goes hand in hand with adoption. So even though in the convention we kind of see it alongside foster care, and the way that foster care is written in the convention, we don't know if it's a long-term placement or a short-term placement. Here, kafala, which is really the practice, just goes along with adoption with the following descriptions. So it's an appropriate and permanent solution, alternative family setting, adoption of kafala is not suitable as an initial option for unaccompanied children. This is explicitly stated here. Because if in our mind kafala goes along with adoption, we see it as a permanent solution. In most cases, the unaccompanied children that arrive to Europe, they have living parents. They're in touch with their living parents. So it's very unsuitable for them. Adoption is not really an option for them. And if the provision of the guidelines on alternative care speak of kafala as an alternative or equal to adoption, then we can interpret that it means really a long-term placement option as opposed to a short-term accommodation and residential and reception option. The alternative care guidelines also say that in case when we're considering stable and definitive solutions, those are preferable and they need to be arranged for the child. So once we've exhausted all the measures of accommodating them or reuniting them with the family or reuniting them with the family in another state, then we have to turn to more permanent options as kafala and adoption. But the primary the primary goal for unaccompanied children is to reunite them with family members, either in the country of origin or in some other third country or member state. I will speak briefly now about different stages of the process through which unaccompanied children go generally when they arrive in Europe. And I'll provide a graphic so it's easier for you to visualize. So usually when they arrive, we have to identify them as children. Then we do an assessment of their situation, of their best interest. A guardian needs to be appointed. They need to be placed in proper reception. Then the asylum procedure needs to be applied for them to determine whether they have a valid international protection claim. We have to ensure that they have throughout this process access to rights as children. And then regardless of the outcome of the asylum application, whether their application is refused or they're granted refugee or humanitarian status, we need to think about durable solutions in their case. I've made this graphic just for you to be able to visualize more the path that they go through, and I'll quickly just go through the different stages and speak about the aspects of that process that particularly relate to Muslim children. And I will point out where we are really dealing with fostering in this process and in exactly what format. Usually when a child arrives in Bulgaria, most of the children we get are from Syria, Pakistan, lately mostly from Afghanistan. Most of them are teenage boys. And this goes to the point that has been raised a couple of times in the presentation about the desirability of the children for foster placement or for adoption. This is a very difficult demographic to work with, and especially assure their access to rights and their placement in services. There's still this very much bias people who want younger children. Of course, this is very unfortunate because these are still children under the age of 18, as is the convention standard. And it's an ethical consideration for us to have. Do children that arrive have to have particular characteristic to qualify for suitable care? Usually in a lot of these cases, what we have is dispute of their age. A lot of institutions dispute that the children are older, they're not really children. That's why their access is often denied to services for children. There's age assessment processes in place, which tell us that the international standards say that those need to be interdisciplinary. So we need to have a psychosocial assessment. But in most countries, still, unfortunately, Bulgaria is one of them, we mostly do assessment, medical text, x-rays, which are very invasive and should not be conducted according to the medical community when there are no medical indications. Once the asylum application is lodged, the child is formally asking international protection in the country in which they arrive. So this is when their asylum claim is lodged. In our context, and I think mostly in Europe, then they go in special reception. This as well is very unfortunate because in most cases we place children in big reception centers, oftentimes with unrelated adults. This situation persists because we continue and we tend to see these children first and foremost not as children, which is what the convention dictates, that they should not be discriminated on the basis of their migration status, but we see them as asylum seekers. So it's the asylum seeking status, which should just be one characteristic of their case, which is the leading characteristic and really determines their access to reception, their access to services and to other rights. There is a movement, and it's exactly here the debate about the provision of alternative care for children in the asylum process is to move away from accommodating them in big reception centers and accommodate them in foster families or accommodate them at least in some small group homes and smaller residential services. the access, at least in Bulgaria and in many other European countries, of these children to the child protection system, I said, which is already not adequately meeting the needs of national children, is very difficult. It's here especially where a lot of Muslim friends of mine have come forward, especially when we first started seeing people arriving from Syria. They were among the first ones that expressed desire to foster children, and especially Muslim children. They saw it, as was mentioned in the presentations before, as a religious duty, as a charitable duty. What I want to mention here is that it's a reception that we first see the possibility of fostering. It's short-term fostering, usually for the process of completion of the asylum procedure. So between reception and decision. From decision onwards, we think about durable solutions, longer-term options. It's one option where we can have fostering as at the reception and asylum examination stage. In Bulgaria, it turns out it's been very difficult for foster families to take this on these children. International good practice has shown that we have best outcomes when these children are placed with members from their own communities, because they really understand what they have gone through, and there's not really such a cultural clash. Sometimes it's not necessary that if we have Muslim children placed with Muslims in Bulgaria, this would necessarily be a good match. A Muslim in Bulgaria who has stayed here or studied in a Middle Eastern country would not necessarily have the same understanding of Islamic ritual and practice as an Afghani unaccompanied teenager coming to Europe. So Islam is, of course, context and contextual practice, and these are considerations that need to be taken into account. I don't think, unfortunately, in the child protection sphere, we have necessarily the specialists who have the knowledge to make these determinations. But I think if the communities get involved more in that process, this could be very fruitful. Another hurdle, of course, is that a lot of the migrant communities in Bulgaria don't have citizenship. And for them to be foster parents at that stage, they need to have citizenship. It's a very long and onerous process. In our context, being a transit country means that the children are passing through relatively quickly at times, which makes it even more difficult for even people who desire to become foster parents to these children to become. Once the child is placed in reception, usually in a big reception center here in Bulgaria as part of the State Agency for Refugees, they go through the registration interview, which takes down the initial details about them and registers them as an asylum seeker officially. At that point, a guardian and a social worker is appointed. And I want to emphasize this a little bit, because here what we mean by guardian is something maybe quite different than what we mean in the context of Islamic discussions on the issue. This is usually and should be a professional guardian, whether voluntary or paid, but appointed to the state as an independent representative of that particular child. Some countries see this function as unnecessary and duplicating the social worker of the state. But in my view, the guardian really provides a check on all of the other actors who are involved in the case of the child. For example, the lawyer, the social worker, whether they're really fulfilling their functions in the best interest of that individual child. The social worker has a larger mandate, and it's usually the mandate of the state for the well-being of the children on the territory of that state. So the guardian usually here serves just for the duration of the asylum application. This is the case, at least in Bulgaria. So this is someone who is appointed to guide the child through the application for international protection, assist with procedural representation, and that person, ideally, so the European directives say, needs to be independent, free of conflict of interest, and have the requisite knowledge. There is something called the Dublin Application, which means that the child who has members of the family in another European member state could initiate the Dublin Application and could be reunited with these family members in another member state. For example, they apply for international protection in Bulgaria, but they have family members in the UK. Then they initiate the Dublin Application and they could be reunited with these family members. I see here a possibility also for a kafala to play out. We don't have case law on this point, but for example, if the child has kafala, parents in another member state, could they be reunified with them, for example? I'll come back to that point later. But once a child is approved to undergo a Dublin transfer, that means that they will go to the member state where the family members are, and then the application for international protection substantively will be dealt with there. Then we have the asylum examination procedure or the substantive interview, where the individual story of the child is examined against the criteria for international protection. If the child meets those criteria, they will receive international protection, humanitarian assistance, or refugee status. Refugee status gives us larger subset of rights than humanitarian protection. Unfortunately, I think what we are seeing is that those procedures for asylum are still not sufficiently sensitive to the needs of children and the particular forms of persecutions that children suffer. There is a lot more work to be done in this area. I will give one example of Afghanistan, where we have for many years now not really the standard conflict, or what we conceive of as the standard conflict of one standing army against another. We have asymmetrical conflict, which leads to a very large percentage of Afghani children, which are the majority in Bulgaria, to get rejections or on their claims. So more than 90%. So this is where we come to the final stage, which is decision. So if the child receives a final rejection, they, given some procedural safeguards, will be returned to the country of origin. Or if that is, or if they receive international protection, they will stay in Bulgaria, and then we'll think about long-term options and local integration. They cannot be automatically returned, though. The country who is reviewing the application needs to ensure that there are special procedural safeguards taken into account before a child is returned. So his or her life should not be in danger. They need to be returned to specific people or designated facility. Just a quick word, because I know we're advancing with time, about best interest assessment. The general comment number 14 of the Committee on the Rights of the Child mentioned that the best interest of the child in the framework of child rights is a substantive right, interpretive legal principle, and rule of procedure. So it applies through all of these stages. It's not really once that we do the best interest assessment. The guardian needs to watch out that the best interest of the child is observed. The asylum authorities need to observe that the asylum procedure is conducted in a way that observes the best interest of the child. This is a graphic from EASO guidance. EASO is the European Asylum Support Office from 2019, from last year, which gives us very much how all of the elements need to fit around the best interest of the child. So the long-term solutions, the asylum procedure, the child protection and reception elements of the claim. Unfortunately, what we're still seeing is very disjointed pictures. So the social workers and the asylum authorities often conduct separate best interest assessments of the child. Often that leads to asking the same questions of the child multiple times, and they're not necessarily systems that help us synchronize the information that we have on the whole case of the child. Just one example here. This is what we have in Bulgaria. So from identification to return, with application and a potential rejection in the middle, there are two laws that are applicable. So if the child has applied for international protection, the law on asylum and refugees applies. Before it applies, and after a potential rejection, the law on foreigners applies. Those are two different regimes, which in practice means that we really discriminate between children who are asylum seekers and children who haven't applied for international protection or their claim has been rejected. And this is really contrary to the safeguards coming from the Convention on the Rights of the Child. If we view this from a child rights perspective, these children have exactly the same rights and the same safeguards and entitlements apply to both of them, regardless of their migration status. I'll just finish quickly with this. As I said, it's really endurable solutions. I don't think in the short-term foster care option, at least in our context in Bulgaria, kafala is really an option. As the guidelines on alternative care showed, it's more thought of as a long-term option, not as an immediate option for unaccompanied children. It's unsuitable for their case, but as potentially a long-term option. In the cases where we have seen kafala, as the other presenters have mentioned, most of the time the kafala was a relationship that was established in the country of origin, and it's kafil parents who want to reunite with their child in a jurisdiction of the European Union, for example. There is such a thing called the Family Reunification Directive, which allows children who have received international protection in the European Union to unify with their kafala parents who are not residing in the EU. But this still has not been viewed by the courts. It's still a theoretical point. What the courts have looked at is usually the other case of parents with trying to reunite with a child. And we have two exemplary cases from the Court of Justice of the European Union, which interprets another directive. So it's not the Family Reunification Directive, it's parents with a child in a kafala relationship. It concerns the Free Movement Directive. So it means when people are allowed to move freely among European member states. What the court says in that case is that kafala relationship ultimately is not equal to the adoption. So for the purposes of the directive, family member includes the adopted child in the definition of direct descendant, but not the makful. So the makful can come into another provision that says other dependents or members of the household. Unfortunately, that other category doesn't give us the same protection as the direct descendant. Then what we're dealing with there is really the discretion of the state to allow that child to move in freely within the EU or reside on the territory of a European member state. There is also a case from the European Court of Human Rights, Shbihi versus Belgium, which usually the kafala in the context of the European Convention of Human Rights is examined under Article 8, so right to family life. But still the courts retain the discretion to evaluate whether the kafala relationship meets the standards of an enduring family relationship. So they have come up with different standards to do that, such as the time spent living together, the quality of the relationship, the role with which the adult assumes in respect with the child. But I think the important point to take here is that despite the prominence of kafala in discussions about unaccompanied children, most of the time it just comes really into play in durable solutions. We haven't really seen it play out. Even in the case of family reunification, it's still a theoretical point. Most of the case law we have is usually about parents trying to bring or reunite with the child or move freely with the child, and the courts still retain the discretion to say whether the kafala relationship is really constitutes proper family life, or to what extent it equals an adoptive relationship, but the view is that it doesn't really meet the same threshold.
We've had a couple of questions already in the chat box. I think what I'll propose is that we spend a few minutes. I'll give Dr. Yassari, I think she's had a chance to, if you would like. Yeah, okay. So I propose that we break it right now in UK time. It's 4:01. I think we'll just take up until 4:05. And then a 10-minute break. We reconvene at 4:15 for our keynote presentation. And we had reserved a full hour, so I think we have some buffer time that will allow us to recuperate the lost time. So I will now turn to Dr. Yassari to address a question that came up in the chat box. I would also like to thank everyone who we have a great range of many participants attending from across the UK and beyond. I'm really glad and excited to see you all, and I hope that you will stay on and ask your questions, especially in the roundtable at the end. For the moment, for the time being, please continue to send in your questions. Okay, Dr. Yassari, you're on mute. Sorry.
Okay. Okay, so there was the question whether why would there be a difference between children of without parents, orphans, or children with unknown filiation, and children who have living parents? And the difference is exactly what we have on the idea of the prohibition of adoption in Muslim law would be that nobody should be called by another name than the name of their fathers, and that lineage or genealogy shouldn't be mixed. So it is easier to say if a child doesn't have parents or is of unknown filiation, we can afford him a different scheme than children who have parents. And that's why that is one of the reasons why there would be a difference, at least in Iranian law, to have that difference. And I just wanted to point out to something that Rositsa was talking about. When we talk about kafala, we have to be very, like, I'm a jurist, so so it's the kafalas you were talking about is in particular the case from the European Court of Justice was an Algerian kafala, and the court did not understand what it was, because if it was a Moroccan kafala, they would be right, because Moroccan kafala ends explicitly when they're 18. But with a kafala from Algeria, there is no explicit stop. And then the word kafala is only used in the Maghreb and a little bit in Egypt. But you don't have that in any other country. So kafala for Gulf states would be the sponsorship for an employee to come to the Gulf to work there. It comes actually from contract law and from the different part of the law. So we have, as scholars, to be very careful to use at least the country that goes with it, or to say which kind of structure we're talking about, because otherwise all those who are not as informed as we are will always think that kafala is the same everywhere. But it's not. I know that you know that. I just wanted to point that out to the rest, because everybody asked me, also kafala is adoption. No, it's more complicated than that. And I wanted also to thank you, because it shows the many differences that exist to approach the topic, from the way in which Muslim scholars of the 13th century have thought of it, about Muslims in contemporary US who want to be fiqh appliant, and then for the sake of migration and all the other stuff. So it confirms that we still have a lot of to do, and that's a really, really interesting topic. So thank you to the other speakers too.
Okay, I think I should give an opportunity to the other speakers, Nermeen, Rositsa, if you want to add anything quick in 1 minute. But I hope, of course, that we will have more questions for you in the roundtable. But yeah.
me say, Luna's question is really fascinating. She's asking about rituals and fiction. So maybe we can return to that in the roundtable. It's a big question.
Yeah, I saw that's a question actually that's of particular interest to me, because that's how sort of as a historian I myself became very interested. But I think, Nermeen, your presentation also addressed that, and it was very interesting to see how today Muslims who are fiqh-minded are negotiating with the sort of inherited norms, especially related to male kinship, how they're sort of like negotiating those rules today. It's really fascinating, and I think it's a great question. So thank you, Luna, and I do hope that we can kind of bring that question back. Any other questions or comments, Rositsa? If you have a quick.
Just very quickly, yes, Professor Yassari, very much so. I wanted just to stress that the language we have in the defining instrument, which is the convention, is kafala, despite the, as we saw, the very complex term that it is, that somewhere it means one thing, it's just confined to also one region. It's very interesting that we have it in the main instrument. That maybe just points again that it's put there as a lip service, but what we see in practice is a very complicated application. Yeah. From a migration point of view as well, and in the European Union, whatever relationship with the migrant with a migrant child is constituted on the jurisdiction of a member state will be under European law. Most of the times in these, for example, kafala relationships, we're talking about pre-existing relationship, whatever the jurisdiction of origin is. So for Muslims who potentially want to foster or take long-term care of children, that relationship will, if it is constituted here for a migrant or refugee child, will have to be compliant to European or national law as well. And you're very much right that it is an Algerian case. There are Moroccan cases as well. What for me is important in this is that the courts still retain the discretion and try to set standards to evaluate the relationship. So even if we have it as supposedly equivalent in the international treaties, it is not recognized. So what sort of equivalence is that if the court always has to do that evaluation and retains really the discretion to do so?
Okay, I think we all deserve a break. Perhaps you agree. I'll just note that we have a very important question from Catherine Huffman from the US on basically who our audience is as scholars when we say Islamic law prohibits or does not prohibit adoption. I think this is a question that applies to all of us, not only in the panel that we are now closing, but also for the keynote and the other. And I think in the keynote and our next panel, our final panel, we'll have a more sort of focused conversation on what the community, Muslim community in particular in the UK, but not only the Muslim community, a lot of carers who are caring for children of Muslim backgrounds. So this will be a kind of, this will give us the audience that we, at least I here, am sort of involved with. I would like to, I mean, one of the unfortunate things about an online gathering is that there's no way to convey the sense of applause. I've learned to use this reaction button, which I will, and I encourage others to do so as well. But I want to thank all three of our speakers for this really rich and fascinating and important contributions. And I hope that this is not a conversation that ends but continues. Thank you. Let's reconvene. I will say it's already 4:10 at my end. Let's take at least 5 minutes. We'll be back here. I will begin introducing our keynote in about 5 minutes. You can take a few moments long. Okay, but please stay online. Thank you.